Продовжуємо засідання. Прошу
We
запросити
shall
до
continue the
зали
special
Sikora
joint
Kateryna
meeting.
Oleksandrivna.
Please invite Sikora Kateryna Oleksandrivna.
Доброго дня. Розглядається
Good day.
питання щодо відповідності
We
кандидата
shall
на посаду
consider whether the
судді
candidate to the High Court judge's position, Sikora Kateryna Oleksandrivna, is compliant with the criteria of the competition under the law on the High Court. PCIe members are present. Names follow. Norman Oss joining us by video. Mary Kay Butler joining us by video. HQCJ members are present. Names follow.
Ігор Кушнір, Руслан Мельник, Олексій Амелян, Андрій Пасічник, Роман Сабатаж дистанційно, Сергій Чумак.
Roman Sabotage joining us by video. You have the right to make motions and recusals, make objections, and make your arguments. Do you have any motions or recusals? No recusals. The rapporteur is Melnik, Ruslan Bogdanovich. Thank you.
Sikora Kateryna Oleksandrivna.
So, Sikora Kateryna Oleksandrivna, in 2005, you graduated from Dnipropetrovsk National University and earned a degree in law, as well as your qualification, your master's degree. In 2013, you earned your PhD in law. No academic title. From 2003 to 2019, you worked as a lawyer or legal counselor in different enterprises by the presidential decree as of April 11th, 2019. You were appointed at the High Court judge position, and you took the oath on April 11, 2019. You have not been elected to the judges self-governance, HQCJ, the High Council of Justice, and you have not taken any administrative positions. You have scored 360.92 points, and you were admitted to the second stage of the qualification test. Thank you. Would you like to add anything? That is all correct. Thank you. Robert, over to you.
Thank you, Mr. Chair. Mary Butler is the rapporteur, and she's on the screen. Mary, can you hear me?
I do. Thank you.
Please go ahead.
Ms. Sikora, can you hear me?
Так, чую.
Great. Thank you.
Yes, I can hear you.
So thank you. So I first thank you for your cooperation in this important process. I know that you have served as a judge of the High Anti-Corruption Court, which is such an important position of public trust since April of 2019. And some of the issues that I want to discuss with you, you have already answered in other forums. As well, you have provided some written explanations for some of our questions, but I want to review them with you for the benefit of the public who may be watching, but also to be able to be sure we understand your application. So when I ask questions which you know you have provided written answers to, please be patient with us. Thank you. So most of my questions have to do with your asset declaration for the year 2020, as I'm sure you have anticipated. And just to summarize briefly, the issue is not with whether you disclosed the existence of assets, but rather whether you disclosed the value of those assets. And I'm sure, as you understand, the significance of complete information in order to properly allow authorities and the public to evaluate your income and sources of income, and which leads to conclusions about integrity. So the questions which you have faced before and which I asked today have to do with your disclosure in 2020 about assets which you disclosed as belonging to your husband. Could you first, for clarity, explain the time period in which you were married to your now ex-husband?
Ми одружились 26
So we got
квітня
married April 26, 2014, and we got a divorce on April 1st, 2025.
Thank you. So in your asset declaration for 2020, you disclosed 4 apartments and 1 land plot, which you described as owned by your husband. And these land plots and apartments were acquired between the time period 2011 and 2017. Similarly, in your 2020 declaration, you disclosed that your husband owned a boat, a trailer for the boat, and 2 cars, a 2015 Mercedes-Benz and a 2004 Toyota Camry car. With respect to each of these assets, you supplied the response that you had no information about the values. Could you please explain to us how it is, given your sophistication, that you had no ability to determine or obtain information about the value of these assets?
Спробую послідовно
Well,
пояснити.
I will try to explain it step by step. First, 2 real estate objects were purchased by my husband before we got married. So, regarding those 2 real estate objects, I didn't have any legal documents. Regarding the other real estate objects, they were purchased during our marriage. At the same time, I also provided an agreement to him signed by the notary and certified by the notary. That agreement contained only general statements regarding the property. And later on, that is in 2016, our son was born, and the apartments were purchased by my husband in Kyiv. I was absent from the conclusion of contracts, and I didn't have any ownership rights. I didn't have any legal documents, so I didn't know nothing about the amount of those transactions. And for 2 minutes, if I can, I would like to explain why it happened so. My declaration for 2020 was filled out by me based on the declaration of the candidate to the judge's position that I submitted in 2018. That declaration to the judge's position contained the same information regarding the amounts, value of my husband's property, and I have never served as a government official. I didn't have access to the state budget, public budget, nor my husband or his family. So my declaration to the judge's position was the first declaration I ever filled out in my life, and the declaration I had problems with was that exact declaration. The National Agency on Corruption Prevention didn't have any questions during that competition, but still it didn't keep me from filling out, from turning to my husband to clarify the amounts. He said that he could not disclose it, and therefore I filled out my declaration the same way I did for the previous declaration. In the Judge's Code of Conduct, we find that declaring is not a purpose on its own. And it was my belief that I did my best in order to properly declare all the real estate objects owned by my husband. I also got an extract from the state property register, the square area, the address, all that is stated there, and I included that in my declaration. After the complete check by the NACP was done, we summarized the number of real estate objects, we summarized the amount, and NACP decided that was a reasonable ground to transfer this information to the pre-trial. And I was not notified of a suspicion, but I was interrogated just like my husband, but the case was closed for the lack of offense, and that decision is effective now. And to summarize, in retrospect, I have ideas on how I could have avoided that situation, but I would like to draw your attention to the fact that I declared all the property of which I knew from open sources and accessible sources, and I did it on the basis of the previous declaration that was not called into question by the NACP. And after a complete check of my declaration was done, a criminal case was closed, and the NACP guidelines that are used by all those who fill out their declarations were modified by a clause saying that when a married couple there is a married couple and there is a failure of one spouse to state the property of the other spouse is not an offense, it's not a violation. And back then, there was no legal certainty of that situation in the absence of such guidelines that appeared later on. We have always been financially independent, my husband and myself, and we were really independent in terms of finances. We did not ask each other questions regarding that. After the criminal case was closed, I insisted on us making a marital contract. We turned to the notary, we concluded that contract, and I also submitted to you a copy together with my answers to your questions. And according to that contract, he is the owner of all the property registered in his name, and I have no relation to that property. From the moment of conclusion of that contract, he didn't need to ask for my agreements to buy any property. After our divorce, I have an apartment in a parking lot that I got with the help of a loan from my father. So after the divorce, all the property owned by my husband stayed in his ownership, and this is a completely appropriate and admissible situation for me, from my point of view, because we have been financially independent from each other.
Okay. Following up on this information, is it your statement that you never learned the values of the properties that were purchased, the assets that were purchased, until the NACP investigation?
Я відповідально стверджую, що саме
So
так
I state responsibly that it is the case. I never learned of such amounts. I could have had an idea of the amount, but I didn't know the exact amount. And I also couldn't make an evaluation of those property because I didn't have any legal rights to that property. In 2019, I was appointed at the judge's position. This is an important detail. My husband and children stayed in Dnipro, and I lived in Kiev. And I travel. I used to travel to visit my husband and children, now only my children. And I didn't even know where those legal documents could stay. I searched for them in our common apartment, and I didn't find any. So, regarding my awareness of his property interests, is also explained by the fact that we lived in different cities.
And is it your understanding that under Ukrainian law, you had no ability to obtain the records from a notary or some other source?
Я не мала такої можливості.
I didn't have such a possibility, and that is confirmed by the documents that I annexed to my explanations. Before submitting my declaration, I turned to the notary that I turn to often. Article 53 on the notary services. According to this article, no notary, neither public or private, could provide me a copy of a purchase and sale agreement because I was not a party to that agreement. I can only provide agreements that I did provide in the past, but those consents rather did not contain amounts. Because under the law I couldn't confirm the amount, the worth of the property, I did the following. After the case, the criminal case was opened, I learned the surnames of the notary certifying the purchase and sale agreement from the NACP. I found their contact information, and each of them refused to provide me information, and also scanned those refusals and sent them to you as an answer to your question. So the short answer is no, it is impossible under the Ukrainian law.
And is it correct to say that after NABU declined to open a criminal investigation, you challenged the NACP decision in the administrative court, and that no decision of the court has been rendered as of today?
Дозвольте, я уточню.
Let me clarify. Since if with respect to judges of the High Anti-Corruption Court, NABU would carry out the investigation, it would be a conflict of interest. So that's why with respect to us, the pre-trial investigation is conducted by the State Bureau of Investigation.
Yes.
And indeed, And indeed, I was defending myself through two directions, in the criminal legal that I've described in detail and in the administrative legal direction. I really addressed the administrative court. That was a couple of years ago with a demand to cancel and to recognize as illegal this statement and conclusion of the ACP. For a couple of years, nothing was happening to this case, and only at the end of 2025, during the competition, there was adopted the decision on denial in satisfying my claim. At the same time, I submitted the appellate claim to the Administrative Court of Appeal, that's 6th Administrative Court of Appeal. As far as I know, as of today, they have initiated the appellate proceeding, and there is no final decision yet. So that decision on denial in satisfying my claim has not come into effect yet.
And what is the legal basis for your request that the NACP's decision be reversed?
Mm-hmm.
We understand your factual defense. What is the legal basis for your defense?
There, the appellate claim consists of several big chapters. If briefly, one section is about the absence of legal certainty and the quality of the law, because, as I have mentioned, there was no clear algorithm of what I should do in such a situation. But the functionality of the declarations contain such sections as the family member did not provide the information or information is unknown. So the functionality is available, but there is no information of when you can use it. Only later on there emerged an explanation. The second part is that I asked the court to assess the absence of my intent to conceal anything in the declaration when we are talking about these real estate objects. I was drawing attention to the goal of declaration, that the main task is to declare the number of assets, because that allows the public to be aware of that. And besides, I was referring to some procedural violations that took place, in my opinion, that was about the term for the conduct of the full check. And there was also another fourth block, but if concisely, though, that's the main.
Thank you. In your 2021, as a consequence of the process where you were learning information that your ex-husband had provided, did you incorporate that information about values in subsequent declarations?
Yes,
of course. Once this situation developed into the criminal proceeding, my husband either found or got copies. I do not know how it happened specifically, but he provided me with the copies of these sale and purchase agreements. I filled in the corrected declaration. I submitted the corrected declaration, and the copies of these agreements are now available to me. I do not have original copies, but I've also shared the copies. At the same time, I started preparing the draft declaration for 2025, and in fact, given the fact of our divorce, the declaration will be shorter by approximately 3 times.
Thank you. Again, a question about your husband's conduct and perhaps your former father-in-law. There is brought to our attention, I think by civil society organizations, the fact that there were some legal proceedings concerning your ex-husband and perhaps your ex-father-in-law and their business activities, which in which the claim was a failure to pay taxes due. Tell us, as a Hawk judge, how you think we should evaluate that circumstance as whether it reflects on your integrity as a judge. I think the conduct was from 2019, or the legal proceedings are from 2019.
Ви праві.
Yes,
Дійсно,
yes, you are right. Indeed, the civil society organization after Maidan provided information about that. I would like to emphasize that we are talking about administrative responsibility according to the Ukrainian taxation legislation. If in the activities of an enterprise there are some tax violations, then this responsibility is administrative. And according to the general rule, it's imposed on the chief accountant and director. While my ex-husband was the director of the enterprise, my former mother-in-law was the accountant of the enterprises. As far as I know, they have always engaged in business activities. I'm convinced that you know about challenges faced by entrepreneurs in their daily activities in Ukraine. That's excessive regulation from the taxation legislation. That's the difficulty of tax. As far as I know, it was about some formal mistakes. They did not submit some declaration or did not specify the correct amount. So they engaged in absolutely legal business. Yes, they are manufacturing the wheat yeast for bread baking, and that is an enterprise with sustainable economic activities. But like any other business in Ukraine, sometimes it encounters not even a problem. That's the issue that has to be resolved.
And just to clarify, did you have any role in the operation of this business as their lawyer or as a business person?
Після призначення на посаду
After I was appointed to the position of judge, no, none. When we met, it was approximately in 2012, because back then I was already had legal education, of course, and I also had the attorney's license. I gave some advice. I was helping. I was drafting legal consultations, opinions. We had very good relationship. But when I was appointed to the position of the judge, my stay in Dnipro is coming only to looking after my child. That's it. Physically, I just didn't have time to do anything else.
In connection with your 2021 declaration, you disclosed that you received a loan from your father in the amount of approximately $150,000, US dollars, that is. Please tell us the source of your father's income to be able to loan you such a large amount in one payment.
мій батько є
My father is a highly qualified engineer. Starting from 1999, his enterprise has been registered. This enterprise is engaged in highly intellectual manufacturing activities. He is manufacturing automation means for mining industry. Until recently, until this, before the start of the full-scale invasion, all big mining enterprises of our country were equipped with his devices. He is engaged in legal entrepreneurial activities. He has lots of patents, certificates on his intellectual property, and I'm very proud of my father. He got significant amounts of dividends from the activities of this company. And in order to confirm that, in response to the request, I have provided information from about the income received for each month of the specific year. From this information, it is obvious that he could easily borrow this amount to me in one single payment. Besides, while looking through my dossier of the candidate, I saw materials of the special check with respect to myself, and there you can also see information about the income received by my father.
And please tell us what you did with these funds. $150,000.
Я була
I
єдиною
was
суддею
the only judge of the High Anti-Corruption Court who did not have own housing in Kiev, and I refused to accept service housing because my parents had an apartment in Kiev, a real estate object, and they allowed me to live there. What was the point to buy service housing for me if there was no need to do that? At the same time, for me, it was obvious that that story is for a long time, and I had to have my own housing in Kiev. I was looking for a real estate object, and the loan was given to me specifically for that purpose, in order to buy a real estate object. And in January of 2021, I got this loan from my father. In March of 2021, I bought an apartment, a parking spot. An apartment was without any inside work, so it was fresh from construction, as we say, and the rest of money was spent on renovations in this apartment.
And is that the only real property that you own?
Так, абсолютно. Ну, два.
Absolutely.
Паркомісце,
Two,
квартира.
the parking spot and the apartment.
I want to go back to your 2017 declaration to ask you about an apartment in Dnipro of approximately 53.6 square meters. I know you have heard questions about this before. You declared that in 2019, you transferred the apartment to your mother. Is that correct?
Так.
Yes. I guess it's curious, or we're curious about why, given your parents' assets through, as you describe, a successful career of your father's at least, that you transferred the apartment back to your mother, or to your mother.
Мгм. Я є
Yes.
власником.
I'm the owner. I was the owner of that apartment starting from 2006. It was bought at the expense of my parents. And I thought that it was responsible and correct to transfer the right of ownership for this apartment once I moved to Kiev back to my parents. There are several reasons for that. We all know that according to our constitution, ownership obliges. I previously did not understand the essence of this sentence, that the right of ownership imposes obligations. But in order to be owner of the object, you have to maintain it, you have to pay for utilities, and to do that from another city, it's very difficult. And the second reason was some purity of our relationships with my parents. My parents were bringing me in such a context that you have to try to achieve everything on your own. And I'm convinced that in such a manner, I repaid to them a part of the debt that I have to them.
With regard to that apartment, we understand that your mother subsequently sold that apartment to your former father-in-law. And what's curious, what we're interested in is, given the fracture in your relationship with their son, why is your mother selling an apartment to your father-in-law?
Мгм. Мгм. По-перше, я думаю, що
Yes, first of all, I think that here was the question was caused by the fact that my former father-in-law and my son have absolutely same surname, name, and patronymics. At the same time, in 2019, when I moved to Kiev in November, I gifted the apartment to my mother. And I think not later than in 2020, back when we are still married, she really sold it to my former father-in-law. He is not, even my mother, in the understanding of the anti-corruption legislation, is not my family member. And especially my father-in-law, especially former in-law. We are not close relatives or family members. My parents did not need that apartment. They communicated with him. But if you've noticed, my husband in their family, it's accepted to own quite a substantial number of real estate objects. And they took that decision among themselves. So there was no double meaning there.
Thank you. And the last set of questions. I have seen reporting that you have incurred 10 traffic violations between the years 2020 and 2025, and up to 21 violations in 20 to 25. And I understand that many of these are related to speeding captured on cameras involving a Lexus automobile registered to you. And in addition, 2 incidents where where you were found guilty of causing an accident by changing lanes without bodily injury or serious damage. And also that you were charged with hitting a parked car while reversing. And my question is, first, do you accept that these were valid charges? And second, given the importance of your position of public trust, how should we view your failure to comply with these laws and regulations about how to operate your car?
По-перше, дійсно, ці
First of all, indeed, this information is accurate. Two traffic accidents that you've mentioned at the end of your question took place before I was appointed to the position of the judge. One of them, I think, was 20 years ago, and the other one was when I had a very small child. And both of them were caused, as you can see, by my lack of attentiveness. Of course, it's not releasing me from responsibility. No, the administrative responsibility was recorded. I paid the fine. I also have my insurance policy with me, and everything was addressed. With respect to speeding, recorded with the cameras, indeed, this large number of violations, apart from one, concerned speeding, and only one of them was for incorrect parking in the city of Dnipro. With respect to speeding, it is no doubt. There is nothing to be proud here. I am aware of this fact. I can only try to explain how it happened. Some of these violations, the majority of these violations, happened in 2022. When the full-scale invasion started, there were no trains between Dnipro and Kiev for some period of time. I mean, passenger trains. And at the same time, the court continued working, as you know. So we were hearing cases. Some people moved to safer western regions. questions, but at the same time, I left Kiev only for a couple of weeks, and only starting from the end of March of 2022, I returned to Kiev, and I was in Kiev, and I was driving to Dnipro because there were no passenger trains between Kiev and Dnipro. And there were constant air raid alarms, and it was announced you are driving a car and you're listening to the radio, and then you hear that a rare air raid alarm is announced in the area where you are driving. And of course, I was worried, and every time I tried to get from Kiev to Dnipro and vice versa as quickly as possible. All of these speeding incidents happened outside of settlements. Also, I think that in some instances, maybe there could be the situation that the signs with settlement for some period of time were taped over. It was done for security reasons in order to make sure that some subversive groups would not know where they were located. So I fully admit that because of the lack of attentiveness, I could have entered the settlement while driving from Kiev to Dnipro and to exceed the speed limit. But at the same time, in Kiev and in Dnipro, I did not exceed speed limits. And that's quite difficult to do that in view of traffic jams. I'm driving sensibly and I'm following that. And if you pay attention, then in 2025, I had only one fine for speeding. So I do hope that that's a good tendency, and that in 2026 I will have 0 fines for that. But again, there is nothing to be proud of here. And of course, it should not happen like that.
Thank you. I have no further questions.
Thank you, Mary. Questions on this side? No, thank you. Back to you, Mr. Chair.
Дякую.
Thank you.
Пане Руслане.
Ruslan?
Дякую за надану можливість задати.
Thank you for this opportunity to ask some questions to Madam Kateryna.
Отже, оскільки ми вже торкнулися.
Since we've already started discussing the asset-related questions, which constitute the majority of those questions that were asked to you from CSOs and the percent results of your dossier examination, for generalization and understanding of how your actions complied with the requirements of the anti-corruption legislation and the Code of Judicial Ethics, I have the following question. According to provisions of the Code of Judicial Ethics that correspond to respective provisions of the Bangalore Principles, a judge shall be aware of their property-related interests and to take reasonable measures to know about financial interests of their family members. As of the moment of filing the declaration for 2020, you were already the judge of the High Anti-Corruption Court, and you were subject to requirements of the Code of Judicial Ethics. So, did you take, in your opinion, those reasonable measures in order to be aware of financial interests of your husband? Because mostly those questions that emerge concern the property of your husband. And if you did take those measures, so what measures could be considered as reasonable? Just quite recently, I looked through the comment to the Code of Judiciary Ethics, in particular to this article. Indeed, a lot of attention is paid to this particular matter there. Among those examples that were provided in the commentary, in my opinion, I took almost all of those measures. The first one is to orally or in writing request the family member to provide this information. Retrospectively, I understand that I should have done that in writing, but now I cannot correct that in any way. Secondly, they mentioned such a measure as, so you orally asked your husband to provide this information. Of course, I asked him to do that many times, and you got a rejection. Yes. What was the reason? I'm sorry. I will just ask some follow-up questions. Why did he refuse to provide this information to you? If you were family members, you were married. Starting from the time of my appointment to the position of the judge, our relationship was gradually worsening. That happened, of course, not at once. Okay. Because of the worsening of the relationship. Yes, I think so. He told me that he could not find that, he did not know where it was, that it was not important. Previously, you didn't need that, and etc. Can I at once tell you, when you are filing the declaration, the personal account of an ACP allows providing comments. The two most recent declarations that I'm submitting, I was given comments, and they are also available on my judiciary dossier. I'm giving the caution, the caveat that my husband did not provide me with information about the income of his income, because I cannot get that information from the account of the tax service. He did not provide me with information about his cash savings, but I presume that he has them. So I'm trying now to disclose all possible information and to explain my behavior. The second thing that I did in the context of reasonable measures is that I addressed the open registers. I got information about addresses, titles of real estate objects and their areas, but the value was not specified there. So I declared everything I could declare. Of course, now I understand that there was an opportunity to some extent to somehow else act, but I think that our divorce would have happened much earlier. Okay, understood. Thank you for this answer. Probably here I should also emphasize that you've already mentioned that your husband is not a person submitting declarations. You did not have an opportunity to get this information from his declarations. No. We are from families of business people. I've never encountered this process before. I did not fully even understand how thorough you have to be in this respect. And unfortunately, I have to state that by imposing this obligation on persons submitting declaration, the legislator did not oblige, maybe not unfortunately, but still did not oblige family members to provide this information. So all of that is happening purely on voluntary basis inside families. Okay. In this regard, I do not have any other questions, because mostly you've explained that while answering questions of the PCIe member. I would like to ask the following question. Here we have information from CSO Transparency International, and that's the question related to your divorce. At once, I would like to point out that we are not entering the discussion of this matter purely from the perspective of getting some private information. The interest is related purely to legal aspects. So, if you believe that the answer to my question entails disclosure of some sensitive information, especially given that maybe we will be discussing by a person that is your child, then you have the respective right and you can submit respective motions. Please do that before informing this information. So, my question is the following. In 2015, you divorced your husband, and the respective court decision is there. And as a result of that, as Transparency International informs us, and you actually confirmed in your explanations that your minor child lives with your husband in another city. In Dnipro. So the main question that the public is concerned about, wasn't this divorce an attempt to create some artificial grounds for delaying conscription of your husband if he's subject to conscription to the armed forces of Ukraine? And hasn't he received such deferment from conscription as a result of the fact that now he's independently, mostly taking care of your child?
Це питання дійсно дуже
That question is really very topical, given the situation that exists in our country, and I will gladly answer and explain that.
Ми розлучились у
We
2025
divorced in 2025.
Перш за все, прошу звернути
First of all,
увагу, що
please
у
pay attention to the
голосі
fact that
цієї
in the
громадської
letter from
організації
this
неправильно
civil society
процитовано
organization,
рішення суду.
they
Вони напишуть,
inaccurately
що
quote the court
я
decision.
зазначила,
They are
що
saying that
чоловік
allegedly
дитина
I
після
said that the
розірвання
minor
шлюбу
child,
залишається проживати
after the
з
dissolution
батьком.
of their marriage, will remain living with the father. No. At the same time, I have the fourth paragraph of this decision in front of me, and here I see the position of the defense attorney of my husband. For my husband, it was important to state that the child, as of now, stays with him. That was not undisputed issue, no. What was the goal that I pursued? I understand that such an important task as divorce had to be broken down into several smaller ones. The matter of the separation of property was resolved by the nuptial agreement, so it was not the issue at all. As of the moment of the divorce, the child reached the age of 9 years old. So on the 1st of April, we got divorced, and at the end of March, he had his birthday. So according to the family code, Article 160, I'm not mistaken, the opinion of the child regarding that matter is asked only after the child reaches the age of 10. Back then, he was studying in the third class of a school that has only 4 classes. For me, it was obvious that he should stay together with his friends, with his usual teacher, and he should graduate from elementary school in Dnipro, because in any case, after graduation from the elementary school, he would need to go to a new school. Now I've started together with my husband to have a dialogue that I want, starting from September of this year, to move the child to Kiev. For now, that is more a monologue from my side rather than a dialogue, but still, I'm convinced that I will surely resolve the situation in the manner that would be most beneficial for the child's interests.
Щодо бронювання, відповідно до чинного законодавства.
Then regarding conscription, under the current law, the only reason for exemption from conscription is a lonely parent, lonely father, bringing a child. This is not the case for my husband. This cannot be the case because I maintain communication with all of my son's teachers and trainers, his doctors, mental health bringing. I take part in that, and this is not the case that my husband does it on his own. Are you aware of the fact whether his husband is exempt from conscription? No, I don't know of such fact. Okay, thank you. Colleagues, no more questions on my part. Any other questions? Hi, it's Oleksiy Omelyan. In 2024, you also submitted your asset declaration as a private individual. My child goes to a private school, and under the current law, I can get a compensation tax relief. I can get a tax relief, tax deduction. Yeah, so it was exclusively about tax deduction. Okay, thank you. PCIA members, any questions?
No, thank you.
Добре, дякую.
All right. Thank you. Then, Kateryna, you've got an opportunity to address the PCIe members to add or to clarify something. I would like only to thank for this competition, for this possibility to provide explanations, to grow professionally and personally. And I would like also to thank for the 2 new judges appointed last year. We are looking forward to the Hague Court new judges, and I would also like to thank the interpreters. Without them, it would have been impossible. Thank you for your participation in the competition. The interview is completed, and